The late Dr. Geoffrey Edelston was one of the larger-than-life characters who popped up in 1980s Australia. In 1984, the Commonwealth Government introduced the Medicare scheme, Australia's universal healthcare scheme. Dr. Edelston saw an opportunity to make considerable money. He began opening large general practice medical centres, very different from the local, almost corner store general practices that Australians were used to. Famously, one of his medical centres had a grand piano in the waiting room. He did in fact become very wealthy and at one stage owned the Sydney Swans football team. About 1990 it all came crashing down. Part of that process was an investigation by health officials into whether Dr. Edelston had been over-servicing clients to increase the amount of Medicare payment he could claim. Some initial investigations took place and then two officials, Dr. Niehaus and Dr. Dash, decided to refer their preliminary findings to the relevant decision-making committee so that final decisions could be made. Dr. Edelston sought to challenge the decision to refer his conduct to the final decision-maker. Let's be clear about this. He wasn't challenging any actual decision about his conduct because no decision had been made. He was challenging the decision by a lower-level investigator to refer his conduct to the actual decision-maker. He was saying that they ought not to have even referred his behaviour to the final decision-maker. At the time Dr. Edelston made this challenge, the High Court had not yet handed down its decision in another similar case called Bond and the Australian Broadcasting Tribunal. There's a case note on that case too. By the time the appeal decision was made, though, Bond had been handed down, and the full federal court relied on that decision. They said, essentially, that preliminary and procedural decisions, such as the decisions by Dr. Niehaus and Dr. Dash, are not able to be reviewed under the Administrative Decisions Judicial Review Act. Justices Northrop and Lockhart said some decisions will have real impact on a person's rights, privileges or obligations. Some will have no such impact, while others are mere stepping stones, which may ultimately lead to the making of a decision that does affect the person's position. They found that only the decisions that had a real impact were reviewable. Mere stepping stones, like the decisions in this case, did not count as reviewable decisions.